gave the order for the soldiers to invade the chamber of parliament. We don't know. Under the 8 parliaments, we have had perhaps more bipartisan probes covered on television. And we have not had any conclusion for any of them. From Sputnik V. You remember the Sputnik V Chobo Mata? You remember that? I'm reminding you. To cash for seats. You remember that too, right? You remember Konkosa Police, the tape. Remember that? We have had too many of these bipartisan programs. All were shown on TV. Helen,
I've been waiting. With the IGP, lead IGP tape. That was, I guess, maybe one of the more recent ones that you and I remember.
I said there have been too many.
What is the conclusion?
Yes,
I remember there were, in fact, some concurrent reports because. The chair had his own. Chair had his own report. It is
in this 8th parliament that somebody's wife went to sit on somebody's husband's lap. This 8th parliament. It was over this same majority-minority thing. Somebody's husband had the benefit of somebody's wife's 8th parliament. It is this same 8th parliament that has 137 plus 1. It never happened before in our history. It is this same 8th parliament that the parliamentarians, when the citizens felt threatened, they were asking for police guard and actually got police guard. This parliament. So too many things have happened in this parliament.
Very interesting.
I'll bring back the detail. Honorable Ines Ofoseni is joining us. He's a former Minister for Land and Natural Resources, a member of the Parliamentary, Constitutional, Legal and Judicial Affairs Committee of Parliament, former member. Honorable, thank you very much for your time. Good morning.
Good morning, how are you?
I am fine. Tumabiula.
I love you. Adira.
So.
Come there.
Now, Honorable, let's begin this conversation. Tomorrow, Parliament will reconvene, and there are already persons who are anxious and worried that, look, if we don't take care, this could break the 8th Parliament of the Republic of Ghana because of the issues that are ongoing, minority, majority issues, the Supreme Court ruling, etc. You are a lawyer and a former chairman of a committee in Parliament. What do you think?
Well, first of all, let me thank you for the invitation to share my views on this, your wonderful network. The anxiety that is growing and building up in Ghana, I can understand. It's perfectly understandable. It's understandable because of the interference of the Supreme Court in the workings of Parliament by the order they have given stay in the hand of the Speaker. I can understand because the MPP is seeking to depart from the precedent they have set in 2020. And so it adds to the confusion. I can understand that the MPP, NDC are feeling hard done by the situation, in the sense that in 2000 when it happened, no one raised a finger, no one questioned the power of the Speaker to make that ruling. And why should they be treated differently? So I can understand. I simply can understand. Now it's an unfortunate situation in the sense that I think that our democratic experience is established on very sound principles. Those principles are now being tested. One of the principles is the Montesquieu's theory, separation of powers. The power, political power, must not be vested in the hands of one institution. And so the institutions created under the Constitution have been given separate responsibilities. Their jurisdiction is in regards to what they have been established to do. And no one has the right, duty, or if we say privilege, to stray into the purview of another of the 3 arms of government. So you can understand that that principle is now under test. Now, again, we are in a democracy. I mean, ours is about 30 years old. People have said that, well, it's still maturing. What has happened shows clearly that our democracy is not maturing. We are just simply marching on. Because it's my view that when the first decision was taken and now another decision has been taken by Bagwin.
Right.
If that decision were allowed to stand, that clearly would have served to regulate the conduct of members of parliament.
Right.
Especially those sitting members of parliament. I mean, that would be founded on the basis of the rule of law. And what is simply the rule of law? It's the cardinal principles of the rule of law are certainty and predictability. That members of parliament, when they go to parliament, should be able to predict the consequences of their decision or actions with reasonable certainty.
Right.
So now we have distorted that. What we are doing is distorting that principle. Is distorting that rule of law. Is throwing everybody into a state of confusion. And so we cannot say that we are growing. I mean, Obi Meno of Sunjwane lawyers, Obi Meno of Sunjwane once said that repeating mistakes can never be equal to experience. So since we are repeating mistakes, and the Supreme Court is not helping matters. Now, you give a stay of execution. One of the reasons you give is that the people ought to have been heard.
Right.
So you invoke a fair hearing. And I said long ago in the Asin North case, that following the decisions of the Supreme Court, it appeared to me then that the Supreme Court was practicing a jurisprudence of convenience. They didn't take kindly to that,
right?
But I've been vindicated. Because in the Asin North case, the Supreme Court had ruled, had given a temporary measure in which they restrained the Asin North MP, the Achekwesin,
right,
from going to Parliament.
That's correct.
Now, at that time, and even now, we still have people in Asin North. It was okay. It was okay then to deprive the people of Asin North of representation in Parliament. But the Supreme Court is telling us today that it is not okay to deprive the people who have been affected by the conduct of these rogue MPs representation in Parliament. So it appears to me to be a jurisprudence of convenience. If it is convenient to the Supreme Court, they so pronounce. Now, then you have the people of Sal. I don't know when they were reading their reasons for the stay.
Right.
They were reflecting over it. You have the people of Sal who have been denied representation for close to 4 years. That is an issue in itself, and that's a great worry to our democracy. It undermines the confidence of the people in our democracy.
The Chief Justice, is yes. Sorry, go ahead.
And then civil society filed 4 years ago for a decision on what should be done on SAL.
Right.
The case has never been listed. So again, why are you treating the people of SAL differently? Or why are you treating the people of Asin North differently?
I see.
That is a question the Supreme Court must, and that fits into the confusion that is happening now.
The Chief Justice is on record to have said that I was hoping that this cap will pass me by because I am in the eye of the storm. That's the Chief Justice.
You shouldn't have hoped that it will pass him by. You should have taken a stand that this is not my province. This is not, the application for stay of execution is not within the province of the Supreme Court.
Are you saying that the Supreme Court had no jurisdiction?
To listen to that. Because what you cannot do directly, you cannot do indirectly. You cannot superintend over the decisions and actions of Parliament. You cannot. There are three equal arms of government, for God's sake. And you should not be doing things that seek to suggest that you are subordinating Parliament to the Supreme Court. And that is what we are saying. You see, everybody, including you, views, every day you interpret the Constitution to regulate your conduct. Every day. But that doesn't mean that your interpretation is authoritative.
That's right.
The body, we the people, and that's the universal creed of all democracies. We the people say that for finality in interpretation, we vest that jurisdiction in the Supreme Court. When they interpret, we follow. So that is their jurisdiction. But in Parliament every day, in the Jubilee House every day, in the offices every day, we are interpreting the Constitution to regulate our affairs. But that doesn't mean that our interpretation is right. So when they filed an action for a proper interpretation of Article 97, 1G and H, it was incumbent on the Supreme Court to expeditiously determine the application, the rates, the petition, and put an authoritative interpretation on Article 97, 1G. And all of us will follow. That is their province. But also, well, we are not going to interpret. We cannot empanel the court now to listen to the petition invoking our jurisdiction to interpret Article 97, 1G and H. But because of certain exigencies, we are staying the hand. I know what I suspect as a legal practitioner and as a watcher of democracy.
Tell me.
It's just about 7 to 8 days to the effluxion of time for this parliament. You know that?
Right.
Within this period, the Supreme Court will break for Christmas. You know that?
Right.
Parliament itself will break for campaign.
Right.
And reconvene in December to consider the vote on account, because you don't know who is going to win the election.
Right.
And then they break again on the 6th of January, and that's all. They dissolve themselves. So if we do a calculation, effectively, you have less than 30 days, working days, within this period. The long game the Supreme Court is playing is that the Parliament, they will sit out Parliament. Okay? And then that issue now becomes moot. That issue will be moot. So they stay the hand of the Speaker. They don't do anything until we determine the case. And then 6th of January 2025, the lifespan of this Parliament is ended. And the matter becomes moot. And they say this matter has become moot. Meanwhile, they have gotten the Speaker not to do anything.
I see. Counsel, I thank you very much indeed for your time. We're grateful.
You're welcome.
Thank you. That's a former member of parliament for Tamale Central. He's also a private legal practitioner, former member of parliament, and chairman of the Judicial Committee and Constitutional Committee in Parliament. My guest in studio is Mr. Kwesi Kwating, Esquire, freshly minted lawyer, spokesperson for the Education Ministry. Good morning, Counsel. How are you doing?
Yeah, good morning, my brother. I'm fine. How are you too?
I'm greater than Accra. Tomorrow will be a big day. Everybody will be watching Parliament. Will you be watching Parliament too?
I'm sure. Beyond the usual political, for lack of better words, drama that will be played to the gallery of party supporters. A lot of them understands the legal position of some of these matters, and I expect tomorrow to rather be calm. Out there you can cheer up, you can read all the history, try to run your own analogy and interpretation and meaning, and get your party people to have a particular understanding. But when they get to the floor of Parliament, tomorrow I do not expect any qualms. I expect that the members of Parliament are matured people who also have a matured understanding of the law,
right,
and should be able to apply the law, particularly when the substantive matter is still at the Supreme Court.
So what are you saying? That the minority, as we know now, will remain minority, and majority will remain majority? Is that what you're saying?
Unless, of course, you despise the decision of the Supreme Court. You see, first of all, if you ask me, there's even no qualms about it.
Right.
Even in a political practicality, at the end of the day, even the fact that you declare a seat vacant, granted that even same is to be valid, will not even inure politically to the benefit of even the NDC, because at the end of the day, you have just barely less than 3 months to elections. You are unable to even call for instance, a by-election. So politically, really has no impact, and that's why beyond the politics, beyond the law, I felt that it was an exercise which shouldn't have even happened in the first place.
But there's precedence.
You see, I've always maintained that if you want to go on that line, that precedent is, if you look at the facts surrounding that precedent, it's not the same as this in the first place, even Parliament is not bound by its precedent in the first. But you see, there is one point that we are all missing. In that precedent, in the CMS case, the principle of natural justice was strictly adhered to, in the sense that the letter that the New Patriotic Party wrote to the Speaker of Parliament, of course, I mean, detailing how Mr. Siama or Rambo Siama has vacated his seat, they copied Mr. Siama.
Right.
You know, in law, it's tried law and an established principle that the principle of natural justice, even if you look at the whole point
all
about all the term partem and the limo judice in as well. But of course, for the purpose of this discussion, is the right to fair hearing, which is the audio term pattern that we're looking at. At no point can you make a pronouncement, particularly when it affects somebody, without giving the opportunity to that person to be heard.
Right.
And for me, that should, a lot of lawyers are not discussing that matter, particularly the NDC lawyers.
Right.
But I mean, if you read the petition or the suit and the consequential orders that was made by the Supreme Court, it was also one of the reasoning of the court that at no point can you make any declaration or any ruling that affects somebody without giving the opportunity for the person to be heard. And the consequential impact of the breach of natural justice is that it renders any order, any declaration, any decision that you have made void ab initio.
Lawyer Kwame Kufu is a private legal practitioner. He says it is absurd to seek a stay of execution in a case in which the court has not made any orders. There was no jurisdiction in the court. He comes back to say Supreme Court was procedurally wrong in many ways in granting the stay of application, and wraps up to say Supreme Court owes the public a duty to ensure consistent application in the principles of law. It's your senior.
I bet to differ.
Tell me.
It is not as though the application that Mr. Fenjomaki made to the court was only an application for stay of execution.
Right.
First of all, he issued a writ of which the substantive matter has not been heard. The substantive matter had to do with matters of interpretation by the Constitution.
That's right.
By the Supreme Court, as to whether or not the Speaker could interpret or it is a resolve of the Supreme Court to make such a determination. The substantive matter was then coupled with a relief for a stay of execution.
Right.
And if you look at the Supreme Court passage, and even not necessarily the Supreme Court or an other court has inherent powers to grant any order, including the stay of execution. You see, the stay of execution can also be construed as an injunction. In terms of its impact and effect, it's the same as an injunction.
Right.
So, for instance, I walk back to the Ministry of Education. I get a letter that Dr. Oseduchum said that we are unable to work with you. The ministry vehicle and all other, items in your possession. We've sent a security man
to come and
retrieve them, particularly without having given me the opportunity to even hear me.
Right.
In that case, I can run to any court and plead upon the court to grant the relief that, well, they should prevent
restrain them from doing that.
Restrain that on order. So I don't really get where Mr. Kufu is coming from.
But then, if you read your party's constitution,
come again, whose constitution?
Your party's constitution, the NPP's constitution. If you read it, what is captured in Article 79 of the Constitution, the last two paragraphs as H and
that's of the NPP's party's constitution.
No, Article 79 of the 1992 Constitution.
Okay.
If you read it, you find the same inspiration in your party's constitution.
That's Article
79.
Is it 97? Are you referring to 97?
97, right.
The one has become the one of
yes, right.
I think it's 97.
Now, if you read your party's constitution, it does mention, for example, that the moment you indicate that you are representing another flag or another emblem and not that of the NPP, while you are still a member of the NPP, you forfeit your opportunity and your rights immediately. So if you are NPP, and then you decide to run on an independent ticket, you already have told everybody that you are no longer MPP by your constitution.
And that's what I'm saying, that you see, a party's constitution is always subsumed by the constitution, 1992 Constitution of Ghana.
Right.
So that if at any point your own constitution or your own statute or your own laws, if they are inconsistent with any provision of the constitution,
right, which is
the
a
extent
supreme
of the
law,
inconsistency shall be declared void.
Right.
So at every point, of course, listening to other arguments from other lawyers where they even say that the Speaker of Parliament was even based his decision on the standing orders of Parliament. But at every point, those standing orders, whichever how
they are subservient to the Constitution.
Exactly, they are subservient to the Constitution, because at every point the Constitution will be on top. So I'm not sure that question necessarily arises. What arises is, one, the point that I've earlier indicated, that granted without even admitting same, that indeed they've cross-carpeted within the requirement and the dictates of the principles of natural justice. These guys should have at least been given opportunity to be heard and also lay their argument why, in their own opinion or in their own wisdom, they've not cross-carpeted. As soon as you breach the principle of natural justice, it doesn't matter the decision that you've made. It doesn't matter the procedures that you went through. It's void ab initio. That's the first point that we have to lay clear. And I'm saying that even if you move up, and of course, if you read the decision of the Republic versus High Court Accra, ex parte Lai Mensa, the Supreme Court was very clear that failure to grant a party an opportunity to be heard is a breach of natural justice, rendering the decision void. Of course, there are other cases. If you look at Abuaji and GCB, Awuni and Wayek, the court also said same. But even moving away from this,
but this application was granted ex parte.
Yes, it doesn't matter.
It matters. You are asking for both sides to be heard, and you are supporting an ex parte application.
You see, reference is made to Order 25 of CI 47.
Right.
That there are conditions precedent upon which the court can base on to grant an ex parte application. Order 25 of CI 47.
Right.
Except to say that the same Order 25 then makes provision that it should not be, the sale of execution or whatever relief that should be granted should not be more than 10 days.
Right.
Of course, I have heard other legal, submissions, questioning why the Supreme Court even granted more than what the petitioners actually asked for. But you see, in the Rosemary Kwando case, there is a legal principle that has been established that, in fact, the court also has inherent powers to grant more than what you seek for.
But the court,
if it's within the reason of the court.
But the court cannot. There's a dictum by a noble judge who once sat with the Supreme Court, Justice Kluje. He says, in the case of the Republic versus Fast Track High Court, Accra, ex parte Daniels, 2003-2004, Supreme Court Ghana Law Report 364, at page 370, noted that we cannot, under the cloak of constitutional interpretation, rewrite the Constitution of Ghana. Even in the area of statutory interpretation, we cannot amend a piece of legislation because we dislike its terms or because we suppose that the lawgiver was mistaken or otherwise. Our responsibility is greater when we interpret the Constitution. We cannot and must not substitute our wisdom for the collective wisdom of the framers of the Constitution. This is Justice Kluje. And that's your closing thoughts, because
I
Chief Vandal is waiting for you.
I perfectly agree with him. I'm sure it's the more reason why we have the principle of separation of powers,
right,
where each arm of government, based on the Constitution, is allowed to check each other, particularly when it comes to the application of this law. You see, what makes this quite unique is that as soon as of course, like when I was listening to the Honorable Witness, he said at every point, even in our daily life, we make interpretations.
That's right.
But you see, as soon as there is an ambiguity with regards to a certain provision of the Constitution, then reference has to be made to Article 132 of the Constitution. So on any day, we can interpret, we can assign meanings to the Constitution. Right. But as soon as there is ambiguity, and within particular context, there is an ambiguity, because the majority in Parliament, the NPP, said they disagree with the interpretation that you've placed or the meaning that you've placed.
But they didn't disagree in the Kwesi Sharma case back then.
No, I am saying first of all, that even takes me back to the earlier submission.
Let's not be
the natural justice the natural justice principle.
Or the Oterim pattern.
Yeah, or the Oterim pattern. But so the facts are not necessarily the same. But I'm saying that as soon as there is ambiguity, then reference is made to Article 132 of the Constitution. And subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in all matters relating to the enforcement or interpretation of this Constitution.
Well, but Justice Kluje, I just read for you, says that you cannot use that as the leeway to rewrite what the framers of the Constitution, what the drafted intended.
I am sure Justice Kluge, even in making this pronouncement, was sitting as a Supreme Court judge. So at the end of the day, why don't we defer to the Supreme Court to make a determination?
Kwati, thank you very much indeed. You have to go to Onia because
they also want me.
Yeah, before Chief Vanda comes to beat me in the studio. You know, if it says we may charge, I'll be in trouble.
Thank you.
1, 2, 3.
Dive into a world of exhilarating fun, refreshing thrills, and endless splashes at the Marina Water Park inside Lakeside. With a wide array of water attractions, you are guaranteed an unforgettable experience for the whole family. Open Saturdays 10 a.m. to 6 p.m. and Sundays 1 p.m. to 6 p.m. Call 0508 598 948 or 0204 775 044. Follow us on all socials at Lakeside Marina Park. Marina Water Park. Love the experience.
Hey, you're grooving hard to these high life songs. Your steps alone.
Of course, with my High Life Cola drink, everything is so smooth.
But have you tasted the tropical flavor?
So refreshing.
Wow, I got my groove on too with High Life Tropical Drink. It's lit.
High Life Cola, High Life Orange, and High Life Tropical. Exquisite drinks.
Brought to you by Sado Industries Company Limited. Quench that thirst and get that excitement for all occasions with High Life Drink.
Hey, but remember, there is High Life Mineral Water too.
Call 0244 991 991. High Life Drinks. Get your groove on.
This advert is FDA approved.
Radio Development Show Host of the Year 2016-2017.
And the winner is John Hughes. Check.
Hi, my name is Johnny Hughes, your community rights advocate, and I'm still on the quest to bring smiles into your communities with Community Connect on 3FM 92.7. Join me this and every Friday morning at 9 a.m. right here on 3FM, and together we will solve the problems bothering your communities.
I know your program is a program that always get a result. Myself, I'm a witness to that.
What can we do to help your community today in terms of education, health, sanitation, security, and all the issues in between from your community's perspective? Tune in to Community Connect every Friday morning at 9 a.m. as we get interactive live on radio and on Twitter at 3FM 927 and on Facebook at 3FM 92.7. Community Connect, helping solve your community problems.
2.7.
Imagine a place where voices matter, where every corner, every street, every community is a platform.
A big bus moving through Accra, carrying conversations, questions, and the pulse of the nation. This is not just another show, it's your voice on the move.
Join us as 3FM Sunrise hits the road, turning ordinary streets into platforms for extraordinary dialogue. Speak freely, listen deeply, and help shape the conversation that drives Ghana forward.
Look out for the bus and tune in exclusively on 3FM 92.7, your urban lifestyle radio.
Hey, ready to make your drive home epic? It's the 3FM Drive with the one and only Giovanni Killen right here on 3FM 92.7. Weekdays, 3 p.m. to 7 p.m. We're transforming your commute into a top-tier experience. Need a pick-me-up? Our music belt is pure energy, pure vibes. Stay ahead with the Drive Sports, bringing you the latest scores and highlights. Curious about the stars? We've got all the hottest trends, celebrity profile interviews, plus DJ faculty has got you.
Monday, Tuesday, Wednesday, Thursday, Fridays on 3FM Drive. You know where it's at.
This is where the action is at, live on the 3FM Drive on 3FM 92.7. Welcome to the 3FM Drive. That's right.
Accra, Ghana, Africa, and worldwide. Join us on Inspirational Gospel Mix this and every Sunday, 8 p.m. 3FM.